This webinar is for the OVW Justice for Families Grant Program, otherwise known as JFS, and will share information about the Justice for Families Grant Program. The grants to support families in the justice system, otherwise known as the Justice for Families Program, is reauthorized in the Violence Against Women Reauthorization Act of 2022, VAWA 22, to improve the response of the criminal and civil justice system to families with a history of domestic violence, dating violence, sexual assault, and stalking, or in cases involving allegations of child sexual abuse. The program supports the following activities for improving the capacity of communities and courts to respond to families affected by the targeted crimes, court-based and court-related programs, supervised visitation and safe exchange by and between parents, training for people who work with families in the court system, civil legal services, and the provision of resources in juvenile court matters. Eligible applicants to apply directly for this funding are states, units of local government, which does not include law enforcement, courts, including juvenile courts, but this does not include prosecutors' offices, Indian tribal governments, nonprofit organizations with 501c3, legal service providers, and victim service providers. The purpose areas of this program are Purpose Area 1, Supervised Visitation and Safe Exchange, Purpose Area 3, Training for Court-Based and Court-Related Personnel, Purpose Area 4, Juvenile Court Resources, Purpose Area 5, Court and Court-Based Programs and Services, Purpose Area 6, Civil Legal Assistance, and Purpose Area 8, Training within the Civil Justice System. You may notice that Purpose Areas 2 and 7 are not included in this slide, and they are not part of the regular solicitation for Justice for Families, as they deal with more policy and legislative work and are primarily addressed in our technical assistance programs. A little more information on Purpose Area 1. Purpose Area 1 is to provide supervised visitation and safe exchange of children and youth by and between parents in situations involving domestic violence, dating violence, child sexual abuse, sexual assault, or stalking. Grantees providing supervised visitation and safe exchange services are not allowed to charge fees to parents served with OVW funds. Applications and grantees must align their programs with the OVW guiding principles for supervised visitation and safe exchange. A link is provided in the presentation to take you directly to those guiding principles. Applicants must describe safety and security measures, including adequate facilities, procedures, and personnel capability of preventing violence, and adequate standards are or will be, if you do not have a site yet, in place, including the layout and security features of the facility and where in the community the facility is located. Applicants also need to describe how they will develop protocols or policies to ensure that confidential information is not shared with the courts, law enforcement agencies, or child welfare agencies unless it is necessary to ensure the safety of any child or adult using the services of a program funded by OVW. A tip here for writing your application and responding to the solicitation is frequently referring and using the OVW guiding principles for supervised visitation and safe exchange is key to responding thoughtfully and fully to questions in the solicitation about safety and security measures and confidentiality. Additional resources that may be helpful in responding to the solicitation are available under two resources, ncjfcj.org and inspireactionforsocialchange.org, and the publications that are listed there. Examples of activities that can be proposed under Purpose Area 1, they are not inclusive of all the activities that can be proposed, but they are just some examples. Paying for rent of a supervised visitation and exchange site, paying for salaries and benefits for supervised visitation and exchange monitors, paying the salary and benefits for a director or supervisor position within the supervised visitation and safe exchange facility, using funds for supplies such as toys, art supplies, and other items that will help facilitate visits, or purchasing security equipment such as cameras or locks. Purpose Area 5 includes enabling courts or court-based or court-related programs to develop or enhance the following areas. A, court infrastructure, such as specialized courts, consolidated courts, dockets, intake centers, or interpreter services. Community-based initiatives within the court system, such as court watch programs, victim assistance, pro se victim assistance programs, or community-based supplementary services. C, offender management, monitoring, and accountability programs. D, safe and confidential information storage and information sharing databases within and between court systems. E, education and outreach programs to improve community access, including enhanced access for underserved populations. And F, other projects likely to improve court responses to domestic violence, dating violence, sexual assault, and stalking. It is important to note that one or more of the subparts may be addressed when you're addressing Purpose Area 5, but you do not need to address all of the subparts when selecting to respond to Purpose Area 5. A few examples of activities that can be proposed under Purpose Area 5, again, not inclusive of all the possibilities under Purpose Area 5, but just some examples. Examples are to fund a domestic violence coordinator to enhance the process of handling domestic violence cases, create a dedicated or consolidated domestic violence docket using funds to staff positions in support of the docket, create an intake center in the court or in a remote court site in the community to process domestic violence protection orders and other court services. Funds can be used to pay staff such as court staff or advocates, rent, or other related costs. Implement victim-centered opportunities such as a position to screen for domestic violence and provide a voluntary and confidential process to help parents with orders of protection to develop safe and effective visitation plans, parenting time, and address other child-related issues. Fund the translation of court documents, forms, and or provide interpreting services for victims of domestic violence, sexual assault, dating violence, or stalking throughout the court process. Staff a court watch program, including court observers and data analysis of results. Conduct an offender accountability program, resources for abusive partner accountability programs, and the guiding principles can be referred to in the link shown in the presentation. You may also consider these as better intervention programs as well. Enhance or create safe and confidential information storage and information sharing databases within and between court systems using funds for technology, or conduct education and outreach programs about court processes for domestic violence, sexual assault, stalking, and dating violence cases, particularly to increase access for underserved populations. Purpose Area 5, the court and court-based programs and services. There are a few helpful resources that you may find helpful in responding to the solicitation or thinking about ways to enhance the processing of cases for domestic violence cases in your court, including Civil Protection Orders website, the Domestic Violence and Mentor Courts website, and Improving Family Courts under the Family Court Enhancement Project. These are great resources to use, and one of the most important things to remember about Purpose Area 5, as listed by the examples in the previous slide, is that everything should be focused around improving the handling and processing of cases in the court system. Purpose Areas 3 and 8 both address training. Purpose Area 3 is training for court-based and court-related personnel, particularly to educate court-based and court-related personnel and court-appointed personnel, including positions such as custody evaluators and guardians ad litem, and child protective service workers on the dynamics of domestic violence, dating violence, sexual assault, and stalking, including information on perpetrator behavior, evidence-based risk factors for domestic and dating violence homicide, and on issues relating to the needs of victims, including safety, security, privacy, and confidentiality, including cases in which the victim proceeds pro se. Please note that Purpose Area 3 does not specifically include judges. Purpose Area 8 is training within the civil justice system to improve training and education to assist judges, judicial personnel, attorneys, child welfare personnel, and legal advocates in the civil justice system. Purpose Area 8 does include judges. When responding to either of these purpose areas, it is important to be specific in who you are intending to train. Training topics for either purpose area should be substantive on the dynamics of domestic violence, dating violence, sexual assault, and stalking, including information on perpetrator behavior, evidence risk-based risk factors for domestic and dating violence homicide, and on issues relating to the needs of victims, including safety, security, privacy, and confidentiality, including cases in which the victim proceeds pro se. Training can also include topics such as firearms, language access, procedural fairness, civil protection orders, and any other related topics on the dynamics of domestic violence. The proposed activities can be a series of trainings, a newly developed curriculum, or other format, but should not be ad hoc or sporadic, and there should be a clear training plan proposed in an application. Proposed training should be specific, including who will be trained, the number of attendees, topics, and purpose for each training proposed. Commitment to participating in the training should also be included in the MOU, or rather the Memorandum of Understanding, or the Letter of Commitment. Training proposed should not be solely focused on the services of a supervised visitation center to court personnel, court-related partners, and judges, but rather substantive topics related to domestic violence, sexual assault, dating violence, and stalking. Purpose Area 6, Civil Legal Services. This purpose area is to provide civil legal assistance and advocacy services, including legal information and resources in cases in which the victim proceeds pro se to, 1, victims of domestic violence, and also can provide assistance to non-offending parents in matters that involve allegations of child sexual abuse that relate to family matters, including civil protection orders, custody, and divorce, and in which the other parent is being represented by counsel. Both of these, A and B, are separate and can be both addressed in the application responding to a solicitation. You do not have to do both. You can choose one, or you can choose to address both. Additionally, civil legal services should not be a majority of the project under the Justice for Families program, but rather it should be a complementing activity to the project. If a project is mostly civil legal services, then it is more appropriate for the Legal Assistance for Victims program, otherwise known as LAV, and may not be considered for funding under the JFF program. Examples of providing legal services include providing an attorney for direct legal representation for victims of domestic violence, hire a legal advocate to provide advocacy for victims of domestic violence, create a legal clinic within the court to provide legal information and resources to pro se victims of domestic violence, or provide direct representation to non-offending parents in matters that involve allegations of child sexual abuse that relate to family matters, including civil protection orders, custody, and divorce, and in which the other parent is represented by counsel. Under Purpose Area 4, Juvenile Court Resources, the purpose of the area is to provide appropriate resources in juvenile court matters to respond to dating violence, domestic violence, sexual assault, including child sexual abuse, and stalking, and ensure necessary services dealing with the health and mental health of victims are available. Examples include hiring a navigator for juvenile court to help provide options of resources, developing written materials for juvenile court explaining available resources, or hiring an advocate for juvenile court that assists victims of dating violence, domestic violence, sexual assault, and stalking. I'm going to pause here and respond to a few questions I see in the chat that relate directly to the purpose areas. One of the first questions I see is, can a partner abuse intervention, batterer training be offered by a nonprofit agency and still be under Purpose Area 5? Yes. A nonprofit agency could be offering the abuse intervention or batterers intervention program or training and be applicable under Purpose Area 5, but should have a clear link to the court. Another question related to the purpose areas I do see as well is, can Purpose Area 6, Civil Legal Services, be a contract with private attorneys to provide services, or does staff need to provide the services? I'm assuming for the nonprofit organization. The attorneys can be either contract attorneys or they can be directly under your organization. It depends. It's up to you and what would be beneficial in the application of the type of project you are proposing. And I see one more question related to the purpose areas. Can Purpose Area 1 grant be more than one supervised visitation and safe exchange site? Yes, you can propose to cover more than one site. Each site will have the required questions be answered about safety and security and how the policies and procedures will be implemented at each site. A little note about choosing purpose areas. The Justice for Families program is intended to be a coordinated approach to the activities described in the purpose areas. Typically, the Justice for Families solicitation includes the option of applying either for a standard or comprehensive project. Standard projects, applicants must propose activities under Purpose Area number 1, Supervised Visitation, or 5, Court. If you're proposing Purpose Area 1, Supervised Visitation, then you must include another purpose area. That means you would apply for Purpose Area 1 and at least one other purpose area, including any part of 5 of the subsection. If you are proposing Purpose Area 5, Court, then you do not need to include any other purpose area. However, you can if you would like. A comprehensive project would be applicants must address activities under Purpose Area number 1, Supervised Visitation, 5, Court, and 6, Civil Legal Services. Common mistakes in proposed purpose areas that we see in applications are applicants misidentify their project as comprehensive when it is a standard project, including adding purpose areas in that your application does not address. We see this a lot in the abstract or in the beginning paragraph. Maybe you start off as a comprehensive project in your mind and in planning, and then you decide to move to a standard. but you've already stated that you will address all 3 purpose areas in the beginning of the application. Unfortunately, then the rest of your application does not meet those purpose areas, and you are counted as a comprehensive without actually being a comprehensive. So we really recommend being thoughtful and clear about what type of project, so that people who are reviewing your application are not searching for the information about a purpose area that you did not intend to apply for. Purpose area 3 or 8, training, are selected but are not meaningfully addressed in the application, or only focus on training about the Supervised Visitation Center. Sometimes in applications we see that purpose area 1 and one of the training categories are selected, and the only training that is proposed is training on how to use the Supervised Visitation Center. That does not meet the training requirement, as it does not talk about the dynamics of domestic violence, dating violence, sexual assault, or stalking. Purpose areas 5, the courts, and 6, civil legal services, are proposed, but there is really no clear difference in the activities proposed, and they are all related to civil legal services. Please be mindful that if your project is more civil legal assistance, it should not be a Justice for Families proposal, and you should rather look at our Legal Assistance for Victims, LAV, solicitation. Or Purpose Area 5, the courts, is proposed, but the activities are not in or related to the court. When selecting Purpose Area 5, it should be a very clear explanation and relationship to the court and court activities. I see a couple more questions about purpose areas that we'll cover before we move on to additional requirements of the solicitation. I think we already answered this first one, but the question was, can one grant request contain requests for more than one project, such as supervised visitation and civil legal services? Yes, that would be considered a standard project and is a requirement. Additionally, the second question I see is Purpose Area 1 mentioned purchasing security equipment. What about subcontracting with a local law enforcement agency to provide security? Would that be allowable? Yes, an allowable cost under supervised visitation would be to pay a security guard, whether that is through local law enforcement or another agency, to provide security, physical security at your visitation center. Also will be included and will be allowable is cameras and locks and other safety and security measures as well. Under the Justice for Families program, applicants must partner with a court, and be careful, this does not include a police department, a prosecutor's office, or district attorney's office, even if they are co-located in your court. And 2, a nonprofit, non-governmental, or tribal domestic violence or sexual assault victim service provider. Partnership must be demonstrated in the Memorandum of Understanding, commonly referred to as the MOU, and/or Letter of Commitment. Common mistakes we see in these partnerships is that a district attorney's office or prosecutor's office acts as the court partner. The court partner must be a court, and the authorized representative must be the official court representative, typically an executive officer or a chief judge. A governmental victim service provider is the partner rather than a nonprofit, non-governmental victim service provider. That is also a common mistake that we see, is that a governmental victim service provider under, for example, a state or county's Department of Health is proposed as the victim service provider, but it must be a nonprofit, non-governmental, or tribal domestic violence or sexual assault victim service provider and meet the definition in the solicitation. Lastly, we see that partners are not included in the MOU or letter of commitment. A common mistake that we see is that the partners are named in the application. However, they do not appear in the MOU, the Memorandum of Understanding, or letter of commitment. Applicants are generally required to submit an MOU, a document containing the terms of the partnership and the roles and responsibilities between two or more parties. However, courts that are precluded from signing on to an MOU may submit letters or a letter of commitment in lieu of an MOU. Note that the letter of commitment, or LOC, submitted in lieu of an MOU under circumstances other than those described in the solicitation will not be accepted. If you are considering applying for the Justice for Families program, I would recommend to look at the FY22 solicitation for the requirements of who can submit an MOU and who can submit an LOC. This is commonly a mistake, and when organizations other than courts sign LOCs and they are not eligible, an MOU is required. Common mistakes we see with the MOU and letter of commitment is that the MOUs and letter of commitment are missing dates and signatures. They should be new MOUs or letter of commitments for this solicitation and not recycled ones from prior years. Representatives who are not the authorized representative of an organization sign the MOU. Also, it should be the authorized representative, the person who has the authority to commit to a project and receive funds, should be signing on to an MOU. The MOU must be signed and dated by the authorized representative of each proposed partner organization in the application. The letter of commitment does not include all of the required elements detailed in the solicitation. This is probably one of the most common errors we see. In the solicitation, there are specific questions that must be answered in the letter of commitment. Many times we see the letter of commitment be submitted as more of a letter of support and not specifically addressing the elements detailed in the solicitation. The MOU does not specify that partners reviewed and approved the budget. This is an element that is required in the solicitation, that the MOU specifically describes that the partners who signed the MOU reviewed and approved the budget. And letters of commitment are submitted in lieu of an MOU, and the applicant is not a court. That is one of the elements in the solicitation to pay really careful attention to. Implementing OVW priority areas. The solicitation typically specifies OVW priority areas that are optional for applicants to respond to. If you do choose to address a priority area, you may be given additional consideration in your proposal. If you do not address a priority area, no points will be deducted for not addressing a priority area. If you address a priority area, make sure to address it meaningfully and throughout the application where asked to detail how the priority area will be implemented. General grant writing tips. You can begin planning your application prior to the release of the FY 2023 solicitation, which will be released later this year, by using the FY 2022 solicitation and begin communicating with potential partners. In this PowerPoint, which will be sent out to all registered applicants or all registered participants and posted on the OVW website, the solicitation link is here for the FY 22 solicitation. Solicitations can vary by year, but the spirit of the program is fairly similar and stays consistent. So you can start planning those partnerships and having conversations about maybe how you would want to apply to the Justice for Families program. We recommend reading the solicitation carefully. So if you do start using the FY22 solicitation to talk with partners and to see if you want to apply, when the FY23 solicitation is released, you should read that solicitation very carefully as some changes may have occurred. Use the checklist at the back of the solicitation to ensure that you have completed all elements of the application. The checklist will be very helpful as you organize your materials. Review the MOU and letter of commitment requirements carefully and be responsive to all elements. Plan ahead to obtain an MOU and letter of commitment signatures early in the application process. This is probably one of the things that we see most, is that an applicant has done all the work of writing the narrative, creating a budget, and they're waiting for partners, especially court partners, for signatures of an MOU or letter of commitment. These take longer than I think a lot of people anticipate, so plan ahead early, and that is why having those conversations with your partners now so that they're prepared is a good idea. Use the headers in the solicitation in your application. It is really important to follow the headers and make an organized application that is responsive to each question. Be responsive to all questions under a header. And if a question is marked optional, that is the only time it is optional. Otherwise, each question should be responded to and can even be numbered throughout your narrative. Navigating the application process. Please ensure that your organization has a current SAM.gov, System for Award Management Registration, UEI, Unique Entity Identifier Number, and is registered with grants.gov. Ensuring these registrations are current prior to September 1st will help you being able to apply for all DOJ grants, and you do not have to wait until a solicitation is posted to ensure you have active registrations and that are up to date with contact information. All registrations are free. Please note, all registrations are free. So even if you are considering applying, and maybe you don't know if you want to apply to any DOJ grants this year, it is a great idea to have active registrations starting from the beginning of the year. And I recommend September 1st, at least starting to do those registrations. Sometimes if you haven't had some of these before, especially a SAM or a UEI, it may take a couple weeks to verify your entity. So getting ahead of the curve and getting those registrations active and set up before any solicitations are released, if it's the Justice for Families or another DOJ solicitation, will really set you up administratively to apply for a grant. The application process is a two-step process, beginning in grants.gov, so that is why it is important to be registered with grants.gov, and completing the application in a system called Just Grants. If you know you want to apply when a solicitation is released, submitting the SF-424 and disclosure of lobbying activities in grants.gov will allow you to begin the application process fully in Just Grants. And again, to become familiar with Just Grants, you can visit the Just Grants website and learn about the system. On this slide, we have additional resources and contacts. If you have any questions about the Justice for Families program, you can email ovw.jfs@usdoj.gov, and your questions will be answered in a timely manner. If you have any questions about using the system Just Grants, you can email ovw.justgrantsupport@usdoj.gov. You can always visit our website, the OVW website, at www.justice.gov/OVW for more information about the Justice for Families program and our other grant programs. Grant writing tips are also available And the last bullet is previous awards listed. So if you're looking to see who was funded under prior years under the Justice for Families program or other programs under OVW or within your state funded by OVW, you can follow this link and it'll take you to all the awards. It does just list the names of the awards, does not list the content or what is included in their awards. But it can give you an idea of what is funded maybe in your area. At this point, I'm going to go to questions. I see that we have a few already in the chat. So I'm going to go back up to some more about purpose areas. Can one grant request be for DVAP? Not sure what DVAP is, but it's under Purpose Area 5 and Purpose Area 1 and training for Child Protective Services, which would fall under Purpose Area 3. Yes, that would be considered a standard project. Those are all allowable activities, but if you want to clear what DVAP is, I can answer that a little bit more fully. Another question is, again, will this PowerPoint be made available? Yes, we will be emailing it out to all registered participants of the webinar and also posting it on the OVW website. If we contract with a private attorney to provide legal services, are we limited to $81.25 an hour per pay? So I think there's a couple of questions that we would have to, go about that with contracts. So if you're making a contract, you would be limited to that. Sub-awards are different. So if you want to follow up, Susan, with that question, a little bit more detail, you can always email the ovw.jff email box, and we can talk about the difference between sub-awards and contracts. Also, information about the difference between sub-awards and contracts is on the OVW website. DVAP batterers intervention. Yes, so DV accountability program, yes, you would be able to have proposed an application that had a batterers intervention or DV accountability program, supervised visitation, and a training that would focus on child protective services. Another question we have is, we received a 2-year grant for a supervised visitation site in 2004. We did not receive continuation funding and the site never opened. Are we eligible to apply again? Yes, absolutely. You are eligible to apply. Any previous award does not have any bearing unless you are an active award and you have not spent more than 50% of your funds and your funding is not ending. But absolutely, if you have received prior funds and you did not have a continuation funding or you did not reapply, you are more than welcome to apply again. You would be considered a new applicant. Additionally, if you have applied for Justice for Families in the past and did not receive funding, or you did receive funding and you are eligible to apply again this year, you can always email the ovw.jff@usdoj.gov to request comments from peer review to assist in improving your application. Another question I have is the amount available and the number of grants to be funded going to be the same as the past cycle for the coming grant cycle? That is determined by Congress, but it usually does stay fairly similar. On our website, you can see the history of the funding amounts and the number of awards, and they are fairly consistent between about 24 and 26 grants and varying amount of funds available. So it is fairly consistent, and in the solicitation, it usually gives an estimate about expected number of awards to be made. Another question is, can JFF be used to enhance offender compliance in a DV drug court which handles offenders post-civil and criminal domestic violence cases? Yes, absolutely. That is all related to domestic violence, and you can use that to improve that offender compliance court. We have several Justice for Families grantees who do address offender compliance in a criminal setting under the Justice for Families program. If I did not get your question, I'm trying to go back through them. Please feel free to put it again at the bottom if I did not answer your question. I do see one from the beginning that asked about best practices of court watch programs. I do not have that information available for this, but again, if anyone wants to share with her the any best practices for a court watch program, that is okay. I see another question. We currently work with our county family court receiving referrals for supervised visitation. Who would we consider our partners for the grant? Do we need a judge? So your partners for the grant that are required would be the court. So it could be the county family court, and it could be whoever's the authorized official. So whether that the person signing on is the judge or the chief judge or an executive officer or court clerk, but it can be the county family court that you receive referrals from. And you would also need to have, if you are not a nonprofit, non-governmental victim service provider, then domestic violence or sexual assault victim service provider, then you would need to also partner with a nonprofit, non-governmental domestic violence or sexual assault victim service provider. So a judge is not necessarily required. Judges do change, and we understand that, but the support and the partnership with the court as a whole is what's required. Another question we have is, can we use a paralegal and not a lawyer for purpose area number 6? Yes, you may use a legal advocate, a lawyer, or a paralegal. I see another question. Anne-Marie, can you spell out what LDA is? And another question I see is, what is the timeline for these requests? So this presentation was solely an information session prior to a solicitation being released. So the FY23 Justice for Families solicitation will be released later this year and typically is open from about 8 to 10 weeks. So from opening the solicitation to it being due in just grants. A legal document assistant. That could definitely be allowable, but feel free to also email the ovw.jff@usdoj.gov to provide a little bit more information of the tasks that would be included under a legal document assistant. Can I be more specific of when the solicitation will be released? We do not have a solicitation release date right now, so I cannot unfortunately be more specific, but within the next few months. And the deadline would be about 8 to 10 weeks after the solicitation is released. So based on when it is released, the solicitation would follow, the deadline would follow that. Another question is, does the nonprofit have to be a domestic violence center or similar? This organization is a nonprofit that provides coaching, education, and visitation services. Great question. So to be eligible to apply under the Justice for Families program, any nonprofit with 501c3 is eligible to apply. However, if you are not a nonprofit, non-governmental, domestic violence or sexual assault victim service provider, then you will need to partner with one, even though you are a nonprofit. And if you have any more questions, please keep writing them in the chat. And if you don't have any more questions, we have one more question, and hopefully this applies to everyone. More assistance on comprehensive versus a standard project. So a comprehensive project has to address 3 purpose areas. It has to address supervised visitation and safe exchange. It has to address something in the course area, A through F, one of those subsections or more, and it has to have civil legal services. A standard project, however, only has to address either a part of Purpose Area 5, the course, or have to address supervised visitation, Purpose Area 1, and safe exchange, and another purpose area. So it could be a project that proposes supervised visitation and civil legal services, or supervised visitation and training judges on domestic violence. Hopefully that helps clarify. And the solicitation, the FY22 solicitation, also details a lot of different scenarios about a comprehensive and a standard project. A comprehensive project does have a higher funding range, usually around $650, and a standard project has a lower funding range, around $550, for a 36-month award period. Another question about when the solicitation will open. Again, I do not have a date. It is not September 1st. It'll be in the next few months. And another question we have is, do you have to be a certified domestic violence nonprofit? So for the partnership, you do have to be a nonprofit, non-governmental, domestic violence or sexual assault victim service provider. If you are just a nonprofit that wants to apply as the lead applicant with 501c3, that is fine, but you do need to have a partner that is a nonprofit, non-governmental victim service provider, domestic violence, sexual assault victim service provider, and it can demonstrate such. In the solicitation, there is a longer definition that you can refer back to as well. Another question, seeking clarity from the last question and answer about nonprofit requirement. Perfect. We are a nonprofit supervised visitation and exchange center specifically. Do you meet the requirement? So this one is a tricky one. I think we have this one a lot. If you have to look at the solicitation and also refer to whether you provide domestic violence services for victims of domestic violence or sexual assault, direct services. A lot of times organizations, their primary purpose is not that, and they actually could benefit from having a nonprofit, non-governmental victim service provider. But you would qualify under being a nonprofit to directly apply, but you should still have that partner unless you are providing direct services to victims of domestic violence or sexual assault, such as advocacy. The solicitation is on the OVW website, the FY22 solicitation, which was opened last year and has been since closed. It is on our OVW website under how to apply for OVW grants under closed solicitations. It is also linked in the presentation that will be emailed at the conclusion of the webinar. And if you have any additional questions, please provide them in the chat. All right, another one. What direct services need to be provided so that a 501c3 does not need a partner? So in the solicitation, there's quite lengthy definition, actually, of a victim service provider and who would be qualifying under a nonprofit, non-governmental, or tribal domestic violence or sexual assault victim service provider. I highly recommend going straight to the definition to see if you qualify under that definition. So we provide, another question is, we provide direct services of supervised visitation and safe exchange to victims of domestic violence, primarily referred to from the Domestic Relations Court. Is that considered a DV direct provision of service? I would like to get a little bit more information about your program. So please email ovw.jff@usdoj.gov. Sometimes the program qualifies and sometimes it does not. So I'd like to get a little bit more information and we can chat about your organization specifically. Someone, I think, maybe joined the webinar late. It did start at 2 p.m. Eastern time, and it will be posted on the OVW website. Additional question is, are you having any other webinars on how to complete the finance documentation requirements? We are not having any other Justice for Families informational webinars at this point. Both last week's and this week's will also be posted on our OVW website under resources for applicants and Justice for Families webinars. If you are looking for more support for any budget or finance documents requirements in a solicitation, you can always email our Grants Financial Management Division at ovw.gfmd@usdoj.gov. And there'll be other resources listed on the OVW website on how to complete any financial or budget related materials for a solicitation. Another question we have we are a dual DV SA agency that also runs a supervised visitation center. We also provide court advocacy as part of our services. Do we still need a court-based partner? That is a great question. So I want to refer back to the solicitation and say it is not a court-based partner that is required, but rather it is a court partner. So it should be your court partner, whatever court has jurisdiction to review and process domestic violence or sexual assault cases that you are coordinating with. So it sounds like you provide court advocacy. So whatever court you are providing those services in would be your court partner. Another question I see is, how do we show a partnership with a sexual assault center? The partnership will be shown and demonstrated through the MOU, the Memorandum of Understanding, and should also be referenced throughout your application in your responses. Absolutely. I'm going to put in the chat the email for Justice for Families, and then our Grants Financial Management Division. I will also put in the chat for any financial or budgetary questions about a solicitation. Oh, that one, my finger slipped on that one, so don't click on that one. And there we go. All right. Does the partner need to be part of the grant? Do they need to be in the same county where the program would run? So the partnerships should be meaningful, and they should be referenced throughout your application and demonstrated in the MOU or letter of commitment. They do not necessarily need to be in the same county that you are in. I know in a lot of rural areas, you don't have a specific, there may not be a specific functioning nonprofit, non-governmental domestic violence or sexual assault victim service provider, but it should be an organization that could provide support and services within your county or service area. Feel free to keep adding questions. And if you'd like to drop off, you are more than welcome to. And any remaining questions will be included in the recording of this webinar. And additionally, there will be a recap of the questions from last week and this week posted on our website as well and sent to any registered attendees. And if you think of a question later on, please do not hesitate to email at ovw.jff@usdoj.gov, and you'll receive a timely response with your questions, as sometimes questions are a bit more complicated and very specific to your program or organization. I'll leave the webinar open for the next 2 minutes. All right, we have another question. Can you partner with a legal private firm or have to hire attorneys individually for the grant? That is a great question. You can absolutely have additional partners, such as a legal private firm that you can work with to support civil legal services under the award, under the application. That wouldn't qualify as your nonprofit, non-governmental victim service and sexual assault service provider, but it would be a great partner. And if that is the direction you're going to go in, you should definitely have them on as a partner in your application. An additional question is, can any of the purpose areas, in addition to be partnered with a faith-based entity? Absolutely. You can, we do encourage, we encourage culturally based and faith-based entities can absolutely be partners in your application. Another question is, how many applicants were there for the most recent round of this grant? We don't publicize the number of applicants. We do publicize the number of awards. So you can check our OVW website and you will have the listed number of awards listed on the website. I'm going to end. Are you able to share a typical award amount? Absolutely. So the cap for the different programs, the different projects, the standard is $550, and typically $550,000 is what people are awarded during the standard, unless they ask for less. It's depending on, up to $550. And for a standard project or for a comprehensive project, $650,000 is the cap, and usually those are the typical award amount for a comprehensive project as well. Yes, that amount is for over a 36-month period. Great question. And again, feel free to drop off the call and follow up with questions on email or to schedule you can always email to schedule another chat if you have additional questions. Happy to answer questions. Is there other funding from other organizations considered a positive attribute when requesting this grant? I think showing, that that's a little tricky one to answer. So I don't think there's a downside. We have a lot of programs that start from the beginning and maybe don't have other funding, and organizations that do have other funding sources, but a strong application will show the need for why you're applying for this funding source. Probably as clear as answering that. It depends on how it's written and what you're specifying the need for requesting funding under the Justice for Families program. I'm going to leave the webinar open for just a couple more minutes, see if there's any remaining questions. I'm not seeing any more additional questions, so I'm going to go ahead and stop the recording here.